So now we are getting to part two of my breakdown of this whole Workday recruiting AI situation that is playing out in the legal courts. If you missed part one, I will hyperlink it over here, a box somewhere on the screen. But today I wanted to get into what was Workday's reaction and what were some of the arguments that they presented to basically say, like, actually, we don't think this is a thing. So let's not proceed further with this. So as you can see here, first and foremost, Workday has three claims. Number one, it's the fact that it's claiming it doesn't offer employment recommendations. So this is a really critical one because this entire case is built on the fact that the system's recommendations are in fact what is discriminatory across the board. The second thing that they're arguing is that the policy in which the plaintiff has identified is not uniform, therefore defeating the preliminary collective certification. And finally, they're saying that the natural variation of the proposed collective members in this situation would mean that no collective could ever be similarly situated. So again, we go back to the two words similarly situated. I went through this in a bit of a detail in the first video. So again, check that out if you want to go through it. Effectively, it's the way in which the ADEA is premised upon to say that in order for this case to stand, you have to present the fact that the individuals you're including in this are in fact comparing apples to apples and not apples to oranges or something else in between. So this is not the interesting bit though, because the next set of details is what made me go, from both a technology buyer as well as technology implementer perspective. So let's take a look. Essentially, the judge is saying in this case that actually, Workday, you say you're not making employment recommendations, but here are the three things in which I think you might be making employment recommendations. So first and foremost, on Workday's website, it literally says that our Skills Intelligence Foundation helps you build diverse teams by expanding candidate pools with equitable AI and ML-driven job recommendations. Okay, so word for word right there from their website. Second thing that they're bringing up is the fact that Workday saying if a customer chooses to turn on CSM, meaning you don't have to keep the AI functionality on, the CSM then uses artificial intelligence to parse, et cetera, and the results are sorted as strong, good, fair, low, pending, etc. The third thing that the judge highlighted in sort of helping her think through the process is that when the plaintiff alleges that Workday's algorithms are only trained on incumbent employees at a company. So I want to highlight this because a lot of times AI solution providers will come to us and say like, oh yeah, we train our algorithm based on your existing data. While your existing data may not be perfect and may have reflected some historical things that you don't currently align with as a company. So just because it sounds good and that they're customizing their solution, their training model, and all of that fun stuff to your data, doesn't always mean that's a good thing in terms of intention versus outcome. The other interesting point here is that the judge is basically outlining the fact that, yes, CSM is making recommendations. We don't know what those recommendations or how those recommendations are being used. So there's some question marks here in terms of cause effect, if you will. But the fact that there are question marks doesn't prevent us from allowing this motion to proceed to the preliminary certification of the collective, essentially. So essentially where the courts are at right now is that they're basically saying, yes, go gather more data. There's still we think there's something here, but we don't know. We can't tell unless we gather more data. So everyone go ahead and gather more data. The other bit that I found really, really interesting in this is when Workday continuously to point out to the fact that employers can choose whether or not to use Workday's AI feature. So as a technology developer, they're basically saying like, hey, we just kind of gave you the option. It's your choice as an employer to figure out if you want to hit the go button on that option or not. And the defendant argued that whether or not this feature causes a disparate impact could entirely be dependent on the existing makeup of the employer's workforce. So those two sentences, quite honestly, of the entire 20-page legal document kind of got me. Because number one, from a technology design perspective, you're effectively saying, I've designed a piece of technology. You figure out whether you want to use it or not. I'm going to sell it to you, but you figure out how and when and if you want to use it. So I think as employers, as HR practitioners, there's a lot to be said about how cognizantly we are walking ourselves into situations of using AI tech and tools in everything that we do. And the second thing, going back to what I was talking about from a data standpoint earlier, is that disparate impact being related to whether the employer's incumbent workforce um, makeup is interesting to say the least, because effectively they're saying, I have the technology, the employers are the ones who are responsible for piping in the data. How is it the technology's fault if something or the other might have happened as a result of that? So I can see where Workday is coming from. I can see through the different angles of this. But at the same time, I think more than anything else, this just really gives me sort of the caution flag, if you will, when it comes to how you review your indemnification clauses, when it comes to the level of details that you as HR technology buyers now need to exercise and the level of caution you need to exercise in reviewing the AI-enabled solutions out in the market. Last but not least, the third argument Workday is saying, and again, this goes back to the whole idea of being similarly situated, is they're basically saying like, hey, every situation is different. So we don't know if you met the initial qualifications. We don't know if there was anything that even indicated your age in all of the applications that went through. And therefore, we don't think you would be similarly situated to the hypothetical plaintiff. And therefore, this whole notion of a collective action should not proceed further. So do they have a case in that? Yes. And I think that's exactly why we are where we are today, which is what I call the legal babble of go gather more data. So essentially, both parties have now been ordered to figure out a project plan on how they're going to gather that data, how they're going to inform the potentially impacted individuals to opt in, so on and so forth. This is going to take time. There has been no judgment whatsoever yet. It could still be dismissed, quite frankly. We don't know what's happening. All we know is that there is a saga pertaining to recruitment AI that Workday has developed that is playing out in the core systems as we speak. So, a couple takeaways from all of this. I think first and foremost, it's one, exercising caution and due diligence as an employer when you are selecting the AI technology vendors that you are partnering with. And two, the reason why I've done these two-part series videos is to make sure that you really understand the level of information and the details to which the information are in the market. Because a lot of times I hear conversations like, ooh, you don't want to be at Workday or you don't want to be at this, but like, guys, there hasn't been a judgment yet. So yes, this is playing out in the news primarily. I'm pretty sure the size of Workday and the fact that they're a public company has something to do with this. But again, at the end of the day, this is just something that we are all observing, and no official judgments or anything along those lines pertaining to whether this thing is legit or not has been made as of yet. So I will keep you all posted as this thing plays out. If you are interested in content like this, especially as how AI technology is working in the world of human resources as well as the world of work, feel free to hit that subscribe button and ring that little bell because I do a lot of content on that front.